unacademy. Let's try.
Good evening, sir.
Hello, good evening, Rhythm. Um, I think even your name I have been seeing. Were you my student?
Sir, I am your student. Yes, sir.
ओके ओके मैं क्योंकि रिदम जैम नाम थोड़ा यूनिक है तो इसलिए याद आ रहा है मुझे ओके फाइन सो आई होप यू आर कॉन्फिडेंट इनफ नाउ टू फेस योर एडीए इंटरव्यू
Yes, sir. I am.
गुड गुड सो लेट्स स्टार्ट विद योर इंटरव्यू सो पहला क्वेश्चन नॉर्मली यही होता है कि इंट्रोड्यूस योरसेल्फ सो लेट्स स्टार्ट विद द इंटरव्यू प्लीज इंट्रोड्यूस योरसेल्फ
I am Rhythm Jain. I am from Nakodar. It is a place in Jalandhar district. I completed my graduation from University Institute of Legal Studies in 2022, and currently I am pursuing Masters of Law from Department of Laws, Punjab University.
ओके व्हाट इज द टॉपिक ऑफ डिसर्टेशन
So the topic of my dissertation is plea bargaining and its comparative analysis.
Oh, you'll get a lot of questions on these. Okay, what is plea bargaining and what are some Supreme Court's views on plea bargaining?
So plea bargaining is the plea of the accused in which he accepts the guilty in exchange of lesser sentence.
Mhm.
Sir, as regards judgments are concerned, I am not able to recall exactly any Supreme Court judgment, but yes, there is a Gujarat High Court judgment in which they uphold the constitutionality of the same. That is Natwar Harchandji Thakur versus State of Gujarat. The court held that plea bargaining is a constitutional concept and it is not unconstitutional. It is based on the ideals of speedy trial.
Okay, but the Supreme Court has held that this is actually a necessary evil, and we are not very fond of plea bargaining.
Yes.
जब मैंने आप मेरी क्लास नोट्स देखिएगा उसमें मैंने दी हैं आपको दो जजमेंट दी हुई हैं गुजरात वाली भी थी बट एक सुप्रीम कोर्ट की भी है उसमें ओके हाउ मच मैक्सिमम पनिशमेंट कैन यू गिव इन प्ली बार्गेनिंग
Sir, as such, it depends upon the type of the offense which the court is dealing with. The maximum
What
punishment is half of the.
Is it half?
Yes, sir, it is half of the punishment.
Okay. And what about अगर minimum punishment दी हुई है तब?
So then also, court will give half of the punishment.
Okay. And suppose tomorrow the accused does not want to go into plea bargaining. If any confession which is already made, can it be used against him?
No, sir, there is a specific bar in the Criminal Procedure Code 1973.
Okay. What is that bar?
So that his statements in the plea bargaining cannot be used in any other trial against him.
Can it be used in the same trial against him?
Yes, sir.
Okay. Which offences cannot be, there can be no plea bargaining allowed on which offences?
So offences which are punishable more than 7 years, and
Okay.
offences against women and children below 14 years of age, and socio-economic offences.
Okay. Okay, let me correct you. हाफ जो है वो मिनिमम इम्प्रिजनमेंट जहां दी गई है वहां हाफ दे सकते हैं अदरवाइज प्ली बार्गेनिंग में 1/4 दे सकते हैं
Yes, sir. So, but as you asked that how much maximum punishment can be given, so
Yeah. तो
that's
मैक्सिमम
why I
क्या
replied.
होता है दोनों को क्लियर कर देना कि जहां
Yes, sir.
मिनिमम इम्प्रिजनमेंट दी हुई है वहां हाफ है और बाकी जगह 4 ओके व्हाट इज द समरी ट्रायल
So, summary trial is a type of a short procedure. It is given under the Criminal Procedure Code 1973. In this, the court adopts a shortcut procedure for the trial.
Is there any summary trial in CPC also?
Yes, sir. Order 37. We have summary suits.
Summary trials in a summary trial in CPC. What is the procedure?
So the procedure is firstly the plaintiff has to file for the summons to the defendants, and within 10 days defendants has to file the appearance, and then again within 10 days plaintiff has to file for the summons of the judgment, and again within 10 days defendant has to apply for the leave to defend the suit.
Can in CPC a suit be decided without calling the defendant? in a summary suit?
No, sir.
Yes.
Defendant has a right to file for the leave to defend.
No. If the defendant gives an answer which is in words of, I'm using the words of the Supreme Court, it is mere moonshine, then he may not be given the right to defend. This is the
Indeed, sir.
only
But
place.
yes, sir.
Mhm. Go ahead.
Sir,
This is the
I
only
thought that
place
both
which
are
is.
different. That
अच्छा, नहीं.
not calling the
When
defendant at all and not allowing him to.
No. अब क्या होता है? It depends on when the second summons is given. For that, when the defendant gives his reply, the court has to decide now whether it has to allow or not to allow the
Yes, sir.
defendant. Okay. What is the under what conditions can a probation be cancelled?
Sir, probation can be cancelled when the person who is bound by the probation has violated any of the condition.
Okay. What can be those conditions?
So, some of those conditions can be that he has not to leave the specific territorial jurisdiction, and other can be he has not to.
He's committed another offense then?
Yes, sir.
Will you not? Okay. What is the evidentiary value of 161 CRPC statement?
Sir, they are only relevant for the purpose of contradiction. They do not have any evidentiary value on their own.
Okay. Suppose the police officer has got a 161 CRPC statement signed, then does it become inadmissible?
No, sir, it is a mere irregularity. If the court thinks that witness has voluntarily given that statement, then court can proceed on it. It is merely irregularity.
Okay. Can a police officer refuse to investigate a case?
Yes, sir, there are two conditions given in the CRPC only where he can refuse to investigate the case.
Okay, what are those conditions and under what provision?
So Section 157 proviso deals with those two conditions. One is that the case is not serious enough to investigate, and second is that there is not any sufficient ground to enter into investigation.
Okay, fine. Taking cognizance, can a JM2 take cognizance?
Yes, sir, only if he is.
Only if he.
Only if he is empowered by Chief Judicial Magistrate under Section 190.
Okay. Why is Arnesh Kumar judgment important?
So because it deals with the criteria of the justification of arrest that police has to comply with the procedures under Section 41.
Okay.
Subsection 1.
Under what conditions can a PP withdraw a case?
So PP can withdraw a case under Section 321 of the CRPC. He can withdraw the case before judgment only. And if he withdraws before the framing of issues, the result is discharge of the accused.
Are there any grounds given on which he can withdraw the case?
No, so there are not specific grounds given.
Okay.
However, consent of court is required.
Okay. Is the PP bound to accept to go with the orders of the Home Department regarding withdrawal of a case?
No, sir. So there is a judgment of Shivanandan Paswan versus State of Bihar. In this very case, one of the dissenting opinion, I am not able to recall the justice's honorable justice. He said that PP is bound by his prosecution department, but majority opinion was that he is not bound by his department. He is not a servant. He's a servant of the public.
Okay. Okay. How many amendments have been there in the Constitution till now?
So 106.
What is the last amendment?
Sorry, sir, I'm not able to recall.
Okay. Is there any reservation for Anglo-Indians now in the Parliament and in the state assemblies?
No, sir. By virtue of 102nd Amendment, they have been removed.
Have they been removed?
amendments, their reservation of the seats have been
No, they did
removed.
not actually. Every 10 years it was renewed. They did not renew. They did not remove, but they did not renew. They renewed SC and ST, but did not renew Anglo Indians. Okay, fine. What is the concept of reasonable classification in Article 14?
So the concept which it has been developed in the case of R.K. Dalmia versus S. Tendulkar's case, it
Hmm,
describes that there must be an intelligible differentia where we can differentiate some of the uh, things from the other, and it must have a rational nexus with the object that we are why we are differentiating those from the
fine.
others.
Okay, what is judicial activism?
So judicial activism is the concept where judiciary. Sorry, so I'm not able to recall exactly.
I'll give you a small hint that uh, where does it flow from? In the sense that suppose some orders which are infringing fundamental rights are passed, can the court
Yes,
come into the picture?
yes, sir.
What will be the fate of such laws or orders which are blatantly infringing the fundamental rights?
So they will be declared void by the
Okay.
honorable
Now,
court.
can the court take suo moto action on this?
Yes, sir. Court can take.
So this is judicial activism. Okay. Is there any law, any specific instrument of judicial activism?
No, sir.
PILs.
Yes, sir.
PILs. Okay, no problems. Uh, who's an overseas citizen?
Sorry, sir. I'm not able to recall.
Acha, okay, पढ़ लेना. And what is the difference
Yes.
from an NRI? Okay. What do we mean by republic? We say India in Republic of India. What is the connotation of the word republic?
Sir, republic means the head of the state is elected by the people.
Hmm. Okay. Only the head of the state. That's all. और कुछ भी है रिपब्लिक का मतलब?
Sir, I'm not able to recall exactly.
Okay. Okay. In IPC, is deceit an offense? Causing deceit only.
No, sir.
Okay. So when does deceit become an offense?
Sir, I'm not able to recall exactly, but I think when it is coupled with delivery of the property.
No. When it is coupled with injury. When we go to section 25 fraudulently,
Yes, sir.
with an intent to defraud. Intent to defraud has been clarified by the Supreme Court in Dr. Vimla versus State of Delhi, that it is deceit plus injury. So if it is only deceit, then it is not punishable. But if it is coupled with injury, then it is there. Okay. Now, uh, which judgment changed the law of conspiracy in the world?
Sir, R versus Mulcahy.
Yes, R versus Mulcahy. उसमें क्या चेंज क्या लाए थे?
Sir, that when two persons conspires, it is itself an act. That's why that would also be punishable.
Yes, the very agreement itself is an act. A further actus reus is not necessary.
Yes, sir.
That's the basic thing. Okay. Uh, what is enhanced punishment, under what provisions of IPC can we give them? Tomorrow as PP, you're going to ask for enhanced punishment. Under what provision of
Yes, sir.
IPC can you ask for enhanced punishment?
So section 75.
Okay. How much can you ask for?
Sir, up to life imprisonment.
Under what offences are covered there?
So chapter 12 and chapter 17.
Okay. With offences against property and coins and all. Okay, fine.
Yes.
Good enough. Fine. Okay, how many heirs are there now in HSA, Hindu Succession Act?
So there are 12 years uh, in first entry of the schedule.
क्या 12 है कि 16 है?
Sorry, so I'm not able to recall exactly.
12 थे 1956 में, इनको
Yes, sir,
बढ़ा के
16.
2005 में now there are 11 females and 5 males. मैंने क्लास में
Yes.
कराया था बहुत डिटेल में. Okay, suppose a biological mother has given her son in adoption and the son dies. Can she inherit from her son which she had given away in adoption?
No, sir, she cannot. Section
Okay,
12 clearly deals with this situation.
okay, fine. Uh, what is the difference between a court and a tribunal?
So we can say that tribunal is the establishment of a particular statute where they do not have any much powers as regards courts are concerned. Tribunals are also not bound by some procedures, example CPC, CRPC.
Not necessarily. All courts are tribunals, but all tribunals are not courts.
Yes, sir.
ये पढ़ लेना, इसका डिटेल पढ़ लें कि जजमेंट है एसडी जोशी वर्सेस हाई कोर्ट बॉम्बे 2011 का है, वो पढ़ लेना. बिकॉज़ दिस क्वेश्चंस हैव बीन आस्क्ड इन द लास्ट पीपी एग्जाम्स. Okay, does the concept of falsus in uno is falsus in omnibus, does it apply to Indian law?
No, sir, this does not apply to Indian law.
Okay, what does it mean?
Sir, it means that false in one is not false in all.
Okay, fine. What is the law of corroboration in Indian Evidence Act?
So law of corroboration. Sorry, sir, I'm not able to recall
Okay,
exactly.
okay, is corroboration a rule of law?
No, sir, it is a rule of prudence.
Okay. Now, is corroboration necessary for any judgment?
No, sir. It depends.
Okay. What is the law given in Indian Evidence Act? What does Section 134 say? Can a judgment be based on the evidence of a single witness?
Yes, sir. Judgment can be based on evidence of a single witness.
That means corroboration is not a rule of law.
Yes, sir.
But suppose there is a child witness, or there is a witness, there is an accomplice
Yes, sir.
whose evidence has to be taken. Now, do we not need corroboration?
So then also we do not need a corroboration.
We do. In child, it is always advisable. Wherever the testimony is not sacrosanct, there we need to have corroboration. मेरे नोट्स आप
Sir.
देखिएगा, मैंने जब
Yes.
आपको सेक्शन 114 का इलस्ट्रेशन बी कराया था, उसमें पूरा लॉ ऑफ corroboration पढ़ाया है. तो उसके अंदर जरूर पढ़ के जाना, इस पे बहुत क्वेश्चंस आते हैं इंटरव्यू में.
No, sir. As regards the accomplice is concerned, Section 133 clearly says that even in case of accused, we do not require any corroboration. However, it is a rule of prudence that we require corroboration in case of accomplice.
उसके अंदर ये है कि 114 का इलस्ट्रेशन बी कहता है एन accomplice cannot be trusted. But 133 कहता है that even on an uncorroborated testimony, a judgment can be passed, conviction can be passed. इनको
Yes,
दोनों
sir.
को बराबर का इन्होंने जक्स्टापोज किया था सुप्रीम कोर्ट ने कि एक जनरल रूल बना लेते हैं कि accomplice अगर तो if he is credible, if his evidence is credible, तब तो no problems. But always rule of prudence applies with accomplice, corroboration करवाना चाहिए. Similarly,
Yes.
child witness, similarly interested witness, या कहीं भी जहां टेस्टिमनी वीक हो वहां कोर्ट को corroborative evidence लेना चाहिए.
Yes, sir.
Fine, Rhythm, I think good enough, but I believe you have to just brush up your certain laws. अभी आप CPC,
Yes, sir.
CRPC, IPC और एविडेंस और कॉन्स्टिट्यूशन इन 5 पे ज्यादा ध्यान दो. No doubt they may ask you on partnership also, contract also, but basically ये जो है ना CPS, CRPC, IPC, because ज्यादा काम आपका क्रिमिनल लॉ में रहेगा या कॉन्स्टिट्यूशन.
Yes, sir.
एंड ऑल्सो ब्रश अप द मॉडर्न डे टॉपिक्स. वो भी जो भी अच्छा अभी करंट इवेंट्स का आ रहा है उसको ले लो और उसको करके जाओ, बिकॉज लॉट ऑफ क्वेश्चंस ऑन करंट इवेंट्स विल बी आस्क्ड. फॉर एग्जांपल अभी दुबई में हुई है जो सीओपी का, वो उसके ऊपर क्वेश्चंस आएंगे, या फिर अभी प्रेजेंट सिनेरियो जो चल रहा है हमास वाला. सो जस्ट कीप योरसेल्फ अब्रेस्ट ऑफ ऑल दोज मैटर्स, बिकॉज दे डू आस्क यू अ लॉट ऑफ क्वेश्चंस, बिकॉज इसमें लॉर्डशिप्स नहीं बैठे हैं. सो
Yes, sir.
वो है तो इसलिए उनके क्वेश्चंस बड़े डिफरेंट होंगे जो लॉर्डशिप्स नॉर्मली पूछते हैं.
Yes, sir.
आपका कब है इंटरव्यू?
So 16
ओके, यू
afternoon.
स्टिल हैव लॉट ऑफ टाइम. जस्ट गो थ्रू द बेयर एक्ट, इंडेक्स से शुरू हो जाओ और सारी बेयर एक्ट की अच्छी तरह मास्टरी करते जाओ.
Yes, sir.
थैंक यू एंड गॉड ब्लेस. लेट्स, यू विल डू वेल. जस्ट थोड़ा सा रिवीजन कर लो, बाकी आई फाइंड इट परफेक्टली फाइन. कंसेप्ट क्लियर है, थोड़ी ब्रशिंग अप जरूरत है.
Yes, sir. Sir, I have a doubt.
हम्म.
Sir, as I appeared in Punjab Judiciary interview,
अच्छा.
so I am expecting a question from the board on that.
नो, आपने लिखा है कहीं मैं अपियर हूँ?
No, sir, but they might ask, as I'm from Punjab, that you might have given
हैव
Punjab
यू रिटन
Judiciary.
एनीवेयर?
No, sir, I haven't written anywhere,
हाँ,
but I'm
उसमें लिख
expecting.
दो, उसे बोल. ओके, ठीक है. अगर ऐसा क्वेश्चन आते, डोंट वरी, जस्ट से सर आई डिड अपियर, but somewhere probably my efforts were not adequate enough. That is why I could not play. See the honest answer
Yes,
though. Ki, sir, I tried my best, but probably somewhere my efforts were not adequate enough, so I could not clear.
yes, sir.
Honesty is
So, but
always the
they
best.
might,
Mhm.
as they might ask that your ultimate goal might be to become a judicial officer.
You say, sir, I would be dishonest if I was to say no. हाँ बोलो कि सर अगर मैं नो नो बोलूंगा तो मैं झूठ बोल रहा हूँ. So, sir, I would be dishonest if I was to say no. Every person has a dream to become a judge, but sir, not everybody is lucky enough to become a judge.
Yes, sir.
See the straightforward answer though. Don't make any excuses. We can easily see through the excuses. We always prefer a person who's honest. जो straightforward सीधी बात कर रहा है, उस पे आओ.
Yes, sir.
अब वो कहें तो इसका मतलब है आप जज बन के छोड़ जाओगे. Can I, sir, though I'll be definitely missing this job, but if I'm selected as a judge, yes, sir, I would leave. क्योंकि अगर आप कहो नो, तो हमें भी पता है झूठ बोल रहे हैं.
Yes, sir.
So let's be honest. Okay, that's how we do it. So wish you all the best, Rhythm. बस अपना
Thank you,
ब्रश अप
sir.
कर लो. ब्रश
Yes, sir.
की जरूरत है. Okay, thank you.
Thank
God
you, sir.
bless.